Thank you, Robert. And once again, I do want to thank the DCBA very much for helping us put this together, especially on short notice. It's as you've done with all these other uh, webinars that we've done, it's extremely valuable and helpful to the 18th Judicial Circuit to be able to communicate with everybody this way. So thank you very much for helping us with this. On the traffic court, as you all know, we instituted a cap and continue procedure when COVID-19 hit. Originally, I capped the traffic calls at 80. Because of the social distancing in each of the courtrooms, we can get about 32 or 34 people in those courtrooms. So we capped them at 80. And what happened is as the police started writing more tickets, those new tickets were coming in on top of the capped numbers. And so we were seeing some calls get to 100, 110, and so on. And it was getting, too much crowds down there in that one area for traffic court, especially after Addison had to come in. So in May, when Addison closed, I had to move them in here to those annex rooms. So now I had 3 calls in here, and there's just too many people at that time. So we had to cut the caps back down to 50, and there's still new tickets coming in, of course. So, it's hard to know exactly what number to get to, but that's what we've been operating on so far. The challenge, of course, has become that the court dates for some of these tickets have had to be pushed out by the clerk's office in order to maintain caps and things. So we've had some tickets that are now pushed to maybe May or June of 2021 for their first appearances. And it's just too, those are for some of the bigger writing towns, but it's just getting too far out. And so I've met with all the judges in the clerk's office, tried to come up with a procedure so that we can generate more tickets through, more cases through than just a cap of 50 plus. So the solution has become, after speaking with everybody, kind of what we've called our layered cake approach. So it's 50, 50, and 50 coming in at different times about an hour apart. And hopefully the goal is that the judges will be able to expedite these matters and go through them in an efficient manner, and not everybody hitting the doors and hitting the courtrooms at the same time, but spreading them out enough so that we can handle more cases but not have huge crowds. So we have a structure, a chart here, and Kevin, I think if you could share a screen so they can see what it looks like. Yeah, thanks. So that's the plan as you can see it, and we've just kind of named some of these things. So let's just look at courtroom 1001, 1003, and Downers Grove. The so-called normal call is the calls that they've always been at. So those will be the new tickets that are written that have the first appearance dates coming in. They're going to be at their regular times they always are in those 3 courtrooms. The next time slot is the 9:30 time slot. And that is for those that it says they're continued by administrative order. So some of these tickets, because of the needs to spread out the calls, they've never had quite their first appearance date yet. So, because they got continued by administrative order. So we want to put that batch of cases next, and that'll be at 9:30. And then the 10:30 call are subsequent appearances. So this is things like if somebody wanted to get an attorney and needed time to do that and they're coming back for that, or they needed time to pay and they're coming back for that, or they're trying to finish some aspect of their sentence like public service or something and they're coming back for that. So those are going to be slotted at that last time slot. And the same thing in the afternoon. It's the same idea with 1 o'clock, 2 o'clock, and then 2:30. As far as the police officers are concerned, on these 3 calls, Supreme Court Rule 504 indicating that if somebody does want to have a trial on that first appearance date, that they should be provided a trial. So the police officers will have to be available on those first 2 time slots, which really is not much different than what's happening now anyway. They're usually there anyway for those times. So, but because that second time slot is technically a first appearance date, you could argue about that one way or the other because of the continuances, but we're sort of treating that as their first appearance date as well. So we want the police officers available to come in if there is a trial request on those time slots. The third one, that 10:30 slot, or in the afternoon, the 2:30 slot, we don't need officers for those. It's not the kind of things that officers have to be in court for. So we're not anticipating and we're not requiring them to be there for those. As far as Addison, because of COVID-19 and because of the numbers of people, we had to stagger those times when they first came in here. So their first so-called normal call was at 10 a.m. and in the afternoon it was at 2 p.m. This has kind of been baked into the clerk system now for a while, and the clerk's been issuing a lot of notices. They have to keep notifying people of where Addison Traffic Court has been temporarily relocated to and what time. So it was very difficult to change those times right now. So we just stuck with those. So that's why we didn't shift those over to earlier times. So Addison's being slightly different. The first time slot there at 9:30, that'll be for the subsequent appearance cases in Addison. The 10 o'clock will be for the new cases. The 11 o'clock will be for those continued by administrative order. And then the same thing over there in the afternoon. Now I realize for Addison, the officers may, they'll have to be available if necessary for a trial at either maybe 10 or 11. I'm hoping that, this is a temporary rescheduling in order to get us through some backlog. I do anticipate, this arrangement going back to a more traditional time, soon. I'm figuring the rest of this year, maybe it won't take quite that long, but we got to generate through these cases. And then there'll probably be new arrangements overall on traffic court a little later. But as far as how the calls will be conducted, it's the judge's discretion, of course, and I'm leaving it up to the good judgment of the traffic court judges who know best how their calls go. But we don't anticipate saying, for example, the 8:30 call is now over and now we're going to the 9:30 call. The calls are just going to be heard as a call, just like they are now. The point is the public is going to be coming in these shifts because they're going to be getting notices what time slot they're supposed to be there for. So it's not as if the 8:30 call will suddenly be shut down and then nobody else can approach and then the 9:30 call. So the judges will just be going through the call, calling the cases according to the check-in procedure when people are there. But we're of course hoping that the people show up at or near the time slot they're supposed to show up at. But the judges will go through the call. As far as the attorneys, again, and I'll let the judges speak to this if they wish individually, but we understand the needs of the attorneys having to be in different places, having to Zoom different calls in this county and other counties and so forth. So, professional courtesy, is going to be extended, and we will be flexible and understand that if an attorney shows up and he or she has a case at 8:30, but they also have one at 9:30, or maybe they also have one that they are appearing on at 10:30. I think it's safe to say the judges understand the situation. They will do their best to accommodate that and have the matters all handled for the attorneys in the most convenient manner possible. We can't promise every single time it'll always work a certain way, but I think we all understand, the situation the attorneys have. So We are asking your help though with your clients. You know, try to stay within these time frames. They're done for a reason. It's the health and safety of everybody coming in the courthouse and in these courtrooms. I'm trying to stagger this as best we can. So I think it'll work out okay. And as usual, you know, common sense adjustments will be made by the people on the ground, so to speak, to try to figure out how best to do it. But this is the overall plan as to how we're going to go forward. So, Kevin, you know, the clerk's office has been instrumental in this. I know you're sending the notices out. If there's anything else you want to, you know, inform everybody about, please feel free.
Excuse me. Thank you, Your Honor. I did want to make one point related to how we filled the, let's say for 1001, the 9:30 and 10:30 times, which is, you know, we had a limit of 50 for any of those three different times. And so if there was a court session at 8:30 that had, you know, 120 cases scheduled, and let's say that 50 of them were initial court dates that had been rescheduled, we would move 50 of those into the 9:30 time. But if there were not 50 of those, let's say there was 20 of those, we would then take 30 cases which were subsequent appearances and fill them into the 9:30 time, so that there was not a gap of no activity between the 8:30 normal call and the 10:30 subsequent appearance call. So you will see a mixture of initial court dates that had been continued due to administrative order, as well as subsequent appearance cases in that 9:30 time slot. I just wanted everybody to be aware of that.
Okay, thank you.
Thank
you. Notices have gone out to all the litigants, right, Kevin, as far as their new time slot and things?
Absolutely.
Okay. Judge Dugos, is there anything you want to talk about on that? You're muted.
Just like, I should be used to this with this.
Yeah.
Just like all the procedures, it's just would be helpful for everyone if everyone makes an extra effort to communicate with your clients so they know where they're supposed to go, when they're supposed to go. And I think it'd just be helpful for everybody that way.
Judge Guerin, anything you want to add about how you think this might work?
Thanks, Chief. Yeah, I think there are sort of 2 points that I want to mention. One, with regard to attorney scheduling, I fully recognize, and I think all of us do, that there are going to be times when attorneys are going to have cases on a particular day that are scheduled at 8:30, at 9:30, and perhaps even at 10:30. From my perspective, and I know that I've talked to my colleagues as well, we're going to do what we've pretty much always done. If you're there and you're ready to hear a case, we're going to hear it once and we're going to be done. And if you've got 2 cases on the same day, there's no reason why anybody should come back at 8:30 as well as at 9:30. Just let us know, let the clerks know the way that you always have, and we'll be as flexible as possible. At the same time, try to help us out with, as the chief said, if you've got a case that's supposed to be up at 9:30, if you could try to be there at 9:30 rather than just coming in at 8:30 or at 10:30, that would be very much appreciated. But sort of, we're in this together, and we'll obviously accommodate somebody the best we can. Once you're in the courtroom, frankly, you've got whatever germs you're going to get, and I've got whatever germs you're going to bring in. So we might as well take care of the people who are there. Just try to help us with the flexibility. That's my first point. Second point is, you're probably also wondering when and how we're going to accommodate bench trials. Traditionally, the way that we've done bench trials is we have waited until the very end of the court call and gotten as many people out the door as we can, on the theory that if you have, before coronavirus, if you've got 150 or some odd cases scheduled for a given morning, there's no reason to make those 150 people wait for a half-hour trial to get concluded. We're going to likely still need to do that. But what I will be trying to do, and what I'm sure my colleagues will also be trying to do, is if we have a dead spot where we're able to go to a trial at, say, 9:45 in the morning, we're going to try to do that before we proceed with the other calls. But what you should anticipate in general is that trials are going to be, as they've always been, at the back end of whatever court call we're dealing with. And when I say court call, at the back end of the entire morning or the entire afternoon, just in the interest of getting as many people out the door as quickly as possible. What I'm hoping that having a little bit more flexibility in terms of scheduling slots will allow us to do is give each of the attorneys the ability to show up at, say, 9:30 for a bench trial, instead of right now, if you came to my courtroom, technically that case would be scheduled at 8:30, even though everybody knows there's no way that trial's happening right at 8:30 because of the other cases that are going to have to get out the door. I'm hopeful that we'll be able to say 9:30 and we'll be closer to that, and we'll save all of you an hour of sitting around or an hour of having to jump in and out of the courtroom to handle other things and wonder what's going on. But all that to say, in terms of when we'll be scheduling trials, we're necessarily going to have to be a little bit flexible. We'll try to fit them in if we have a slot towards the back of one of our hour slots. But sort of the default is going to be what it's always been, that when we finish with the morning's cases, that's when we'll roll into any trials that we need to do.
All right, thank you, Judge. Judge Kappas, anything in your call that you want to share?
Yeah, similar to what everyone's already echoed, I think the key here is just really flexibility. And I've told a lot of the prosecutors already, to be as flexible as they can with defense attorneys that are coming in and looking for dates, and as far as putting them on whatever time slot that they may want. Knowing that most of the cases that obviously we hear are pro se, not a lot of representation by the defense bar. So I think putting a case where an attorney may want one at 8 or 9 or 10 on my slot shouldn't be much of a problem, because it'll still give a lot of flexibility and ability for us in the clerk's office to put additional cases on those other time slots. So I think the attorneys and the prosecutors know that I will be flexible as far as the time slot that you want. And I think the order gives us kind of flexibility to really put those cases that are subsequent return dates, or return dates for completion of driving school or public service, to be put on those time slots that can free up those cases for new tickets to be put in, so we can really hear a lot more. And as Judge Guerin mentioned, I think with the bench trials, we'll just have to be flexible. If we can definitely squeeze one in between an 8 and a 9 slot or 9 and a 10 slot, I'm more than happy to do so. Obviously, the key is to try to keep bodies in and out of here as quickly as possible. So we just want to be cognizant of the fact that if we do have bodies sitting in the gallery, we want to make sure we get to those cases first before trial. But I will be flexible, and I think most of the people in my courtroom will be as well. Other than that, I think the key for the defense bar might be just more communication with the clients. For example, if I have set a case at an 11 o'clock slot and they want to have it heard at 8 o'clock, I'm more than happy to do so. Just make sure they obviously notify their client so they're not coming in at 11. So if it's just a time where it's getting continuance or whatever the case may be, we're at least making sure the defense bar is communicating with their clients for the appropriate time that they need to be there and whether or not they need to be there. So other than that, I think just making sure everyone's flexible, we should be okay.
Thanks, Judge. Judge Belford, anything?
I think it's been covered already by Judges Guerin and Kappas, and I would just confirm we're more than happy to build in flexibility, accommodate particular requests for time slots. I just would ask that as attorneys are making requests for particular settings in the future, just keep in mind the purpose of this scheduling procedure. I understand matters of convenience, but to the extent we can also keep in mind why we're doing this when you're making requests for particular times, that there's a public safety, public health element here as well. So that we can all kind of be taking every consideration into account. And I kind of had the same expectation that with respect to trials, that I would hope that we would have the ability at least to plug in, a trial between these sessions, probably more likely after the 9:30 than the 8:30. But our expectation and our plan is to plug in trials wherever they fit, even if that's, you know, between an 8:30 and a 9:30, a 9:30 and a 10:30, and doing everything we can to avoid just putting everything to the end of the 10:30. May not always work, but our hope is that, you know, we will be able to plug out, you know, at least a couple of those before the 10:30 call starts.
Hey, thanks, Judge.
Yep.
Judge Fleming is off today, but this administrative order, and I issued an administrative order outlining this as well. And there was another earlier administrative order for Addison Traffic Court that said originally the officers were not required to appear at these 10 and 2 o'clocks because it was such an emergency and unexpected relocation of the court. With this administrative order, I also issued an amended one of that earlier one, striking that. So they do have to be available now because the initial emergency situation is not to the same extent. So, and again, I realize for Addison, that means a little later in the morning, but again, we're hoping not to have to do this for a long period of time. We'll just get through some of these backlogs and we'll be back in a better footing soon. So I don't know, Robert, there seems like there may be a couple questions if you want to go to those.
Absolutely, Chief Judge. Thank you very much. So we do have, there were a number of questions that were entered that have been answered by the panel. So I think we covered off on those, but one that is still here. We are getting calls from clients who received notices and we were never notified, causing a problem with our schedulers. Is there any way that notices can be or should be sent to the attorney of record as well as the defendant?
Kevin?
I'm not sure which, if we send out many different kinds of notices, which have many different rules around who they may be delivered to. A lot of them do go to criminal defense attorneys. And I honestly, off the top of my head, I'm not sure if these rescheduling notices specific for these times, if they did go out to the attorneys. Let's assume they haven't based on the question, and then, I can look into that. But, basically, most of the prosecutors also do have access to e-access, and they can check their cases and their times at any time as well. The date has not changed, just the time. So I would recommend that they try to find their cases and their times there. But I will look into that. I can't give a definitive answer right now.
Thank you very much, Kevin. Next question. Do you anticipate room 1001 going to Zoom?
We have talked about Zoom, and I've been in contact with other chief judges who have Zoomed traffic, and we've heard of a lot of issues that are popping up. And one of them is that sometimes the traffic calls are going to 4, 5, and 6 o'clock at night. Just because of the nature of traffic court and the people trying to get on. And it's just, I've heard a lot of problems in that area. So I have talked to the clerk's office about it as, a future goal possibly, but I think the nature of it is I still would rather prefer handling it this way. I don't want people waiting for their ticket to be resolved for 3 and 4 and 5 hours in traffic court. So until it can be done in a better system, we're not looking to Zoom traffic right now.
Another question, that's sort of relative to witnesses. Also, to confirm, prosecutors do not need to have the officer in court just on call and ready to come to the courthouse if the case is going to proceed to trial. Are victims in traffic accidents being notified still not to come to court? So a question about police appearance and victim appearance.
I can answer if, and anyone else can chime in. I know a lot of the prosecutors in my courtroom, some don't have the officers physically there in court and either basically they're on standby or at least close by or even waiting in the parking lot just to not have as many bodies in the court. And then if we do have a trial, the prosecutor's letting them know, and then they're coming in, and there's not much delay in doing so, especially if we know there's a trial going to be, and we have a few cases still to get through. The officers are coming in a pretty prompt manner, and I think that's a great time to do so. Other prosecutors have a few of the officers there. So I don't think it really matters to me. I don't know if any of the other judges have an opinion on it. I think it really is the discretion of the prosecutor, as long as they can know that they can get the officer in there if a case does proceed to trial on that officer. And as far as my courtroom, I believe all victims of accidents are being notified to be there. I think my understanding was it was only Addison Traffic Court where they were excused on the appearance for them. But in my courtroom, all the witnesses should be notified, and obviously the obligation of the prosecutor to make sure that they are notified. And I know clerk's office, I do check, they do send out those notices if they are being continued, and we set it for a bench trial. So we do check to see if those go out as well.
Yeah, I think that's right, Judge. Part of that administrative order that I amended, which now requires the police to be available, also it's the witnesses as well. So for Addison, those notices that they'll be expected to be there from here on out. Or available anyway.
If there's no other comment to that question, for Downers Grove afternoon calls only, defendant at first appearance date asks for a time to speak to an attorney. Do we then set it for the 2:30 p.m. call, or do we keep it on the 1 p.m. call?
Yeah, that's actually an interesting question that I'm still thinking through, only because Friday afternoons are a particular example of calls that tend to be on the light side. So what I don't want to do is be setting things at 2:30, and then we end up having a 1 o'clock call with 40 cases on it and nothing on a 2 o'clock call. And now we have, an hour gap with 2:30 cases waiting for a few returns. My understanding from the order is that, if we set something today at 1 o'clock on a future date, and it ends up needing to be plugged into a different time slot, the clerk's office will take care of that. Probably the example, it's Joe, you're the one asking, probably on a Friday afternoon, I would probably have you set future dates for 2 o'clock, just knowing the expected size of the calls on Friday afternoons. We have days where the calls are predictably heavier. On those days, I would probably have prosecutors set future dates for those third time slots on the call. But in particular, Friday afternoon, I would probably do a 2 o'clock return, assuming the clerk's office has no concerns about setting it that way.
We do not. You can set them at any of the times, and to your earlier point, if cases get continued such that we have too many cases set at a different time, we do plan to, circle back and shuffle things around to spread them out as well.
Yeah, and I think that this just goes for the prosecutors who are on the call. You're going to, when you're filling out no-shows, or when you are looking at what dates you would be giving to defense attorneys in terms of times that are available. Sometimes attorneys obviously come in and just ask for a future date, and typically I don't have those brought in front of me just in the interest of efficiency. You're just going to need to know ahead of time what days are typically going to be more busy, and you're going to need to talk to your judges in terms of where they want those future return dates scheduled. I can tell you on certain days, exactly what Judge Belford just said makes sense. There's no reason to set any case for the third time slot, because we never have 150 cases on certain days and certain times. Other days, they are predictably always busy. Monday mornings, I always have pre-coronavirus at least 150 cases. Wednesday mornings, I always have at least 150 cases pre-coronavirus. On those days, we're going to want to set cases accordingly. But this is going to just have to be a little bit more of a flexible process where you're going to have to spend that extra 30 seconds to figure out where things should be scheduled, as opposed to just reflexively putting everything at 8:30 or 1 like we've always had the luxury to do. I'd love to do it. We just don't have that luxury anymore.
Another question on police appearance. Will or have the police chiefs been notified of procedures for their officer appearance requirements?
Well, I did have Carol Doty here in our office send out the administrative order to all the police departments. I would ask certainly municipal prosecutors to make sure their police departments are aware of this procedure. So right now, they are on notice that this is the new administrative order, and in that order, I set out the chart that you just saw. So I believe they are on notice, but I think the prosecutor should definitely follow up with them to make sure they understand this.
Continuing on that theme, specific to Downers Grove and Addison, the attorney, I file a fair number of 505 trial demands on state police tickets. When are those troopers supposed to be there when a 505 notice is filed?
Well, I'll let the traffic court judges answer that, but my understanding is if you fill out that request, then the clerk gives it a date according to the trooper's schedule, and the trooper is there on that date. But either one of the judges can answer that probably better than I can. I haven't been in traffic court in a little while.
Yeah, I mean, I think the concern is more about what time the trooper would need to be there. Is that correct? I assume those would be, and Kevin, you can correct me if I'm wrong, I assume those would be set in the 8:30 or 1 o'clock time slot. I mean, if a 505 notice has been filed, it's a first appearance date, that would be an 8:30 or a 1. Is that correct?
I believe that's true. That would be my educated guess on how the criminal traffic division would enter it. Yes.
Okay, and presumably if it were not, the officer's required appearance time would be whatever time went out on any different notice.
Definitely.
Yeah, so if for whatever reason it got set at a 9:30, that would be the officer's required appearance time. The 505 obviously would still be operational and effective. So, I mean, the date would stay the same and the time would be presumably 8:30, but whatever the clerk's office notification went out. Am I correct?
Correct.
Yeah. I hope that answers the question.
Judge Belford, the facilities department told me that the air conditioning and heating got lost in the judge's chambers in Downers Grove. You okay? Are you okay out there?
We're okay. Yeah. Yes.
Okay.
And the porta potties are up and running, so don't worry.
All right. Well, they're working
out here.
Go ahead, Robert. Robert,
I think you might be muted.
Yeah, no, was actually typing a response to it. So I have one final question / comment in the queue, and I will just read it here, and hopefully the panel can decipher. Is the correct time for motions to vacate the normal, AO, or subsequent dates? I think what is the correct time is probably the question for motions to vacate the normal, AO, or subsequent date slot. I imagine we will be subject to the 50 cap rule in either case and allowed to file if the slot exists.
Yeah, so what's going to happen there is exactly what the last phrase there says. If there is a time slot available for a motion to vacate, My hope or my assumption is the clerk's office would allow that to be filed at the earliest possible time. So if we're dealing with a court call where there's only 30 cases on the 8:30 call in my courtroom, for instance, then that should get slotted in at that same time as well. That's going to be dependent on when you go to file your motion, what times the clerk's office has available and what times they authorize. But they've been encouraged to use the earliest possible time where there are slots available. And with something like a motion to vacate, we should already have a very good idea of what cases are already set for a particular day, because the nature of motions to vacate is that they are typically filed to be heard as soon as possible. So a week or 2 weeks out, we will already know what the caseload is for a particular time slot. And my hope would be that the clerk's office would allow that to be filed in the earliest slot possible, just so that we can avoid having unnecessary gaps of time.
Great. Thank you, Judge. With no other questions in the queue, I would just take a quick moment to make the comment, particularly for the defense attorneys that are on the call today. Should you find yourself in court and in need of a place to take a Zoom hearing in another matter, please know that the Attorney Resource Center is open for that purpose. We've added some laptop stations into the workspaces that are there in the ARC. So if if all you have is your phone and you need something a little more robust to take your Zoom hearing, we're happy to accommodate you. 2 of those laptops are available as long as the courthouse is open. A third is in our locked workroom, but anytime staff is there from 8:30 to 11, we'll be happy to let you in, and that's a very good quiet place to take a Zoom proceeding. So should you find yourself in the courthouse and in need of that sort of space, please know that the ARC is there for you to use. So with no other questions, Chief Judge, any closing comments?
No, I just thank Kevin Vasky from the clerk's office and Jeff Davies as well. I've been working with them on this very much. And thank all the judges for being on the panel today. And again, the DCBA for helping us do this. We will, it's a cooperative effort, and I trust we'll get through this with everybody applying a little common sense and troubleshooting as we go through. And I appreciate the cooperation of all the attorneys helping the 18th Circuit get through this COVID-19 situation. So thanks again, and hopefully Monday, well, we'll see how it goes. I'm sure it'll get smoothed out as the week goes along.